Thank you, Professor. Greetings, everybody. It's an honor to speak to this dedicated group, real experts on water matters. Salman's conclusion provides a good segue for my topic today, which focuses on the impact of Indus Waters Treaty on riparians' internal water governance. In that context, I will talk about specific disputes within Pakistan and India, and I will do that in two segments. First, I will have a segment on Pakistan, and then second segment will be on India. But before doing that, I will very briefly talk about the general setting. I will be brief and will discuss legal and institutional aspects only. First, therefore, let me provide a brief background uh, of the topic, of the issue. At independence in 1947, the irrigation system, conceived originally as a whole, was divided between India and Pakistan without regard to irrigated boundaries. This resulted in an international dispute in 48, which was resolved by the conclusion of the Indus Waters Treaty of 1960. This treaty assigned three eastern rivers, the Ravi, Beas, and Satluj, to India, and three western rivers, the Indus Main, Jhelum, and Chenab, to Pakistan, with a transfer of irrigation supplies from the western rivers to areas in Pakistan formerly served by the eastern rivers, as well as some development potential to compensate for the loss of the eastern waters. Interestingly, the conclusion of the treaty resolved an international crisis, but due to new patterns of demand and supply resulting from the new allocation of water, issues of national water governance surfaced within Pakistan and India. Both countries had to deal with it. They had to make adjustments to deal with the treaty's impact on their national sharing and management arrangements. This is the map of the Indus River system. I should mention that the work under the Indus Basin project, which included the Mangla Dam with a live storage capacity of 4.82 million acre feet, 5 barrages, and 8 inter-river linking canals were completed between 60 and 71. Similarly, the Tarbela Dam with a live storage capacity of 9.3 million acre feet started partial operation in 75-76. Similarly, the Kotri, Taunsa, and Guddu barrages were completed between 55 and 1962 to provide controlled irrigation to selected areas. These are the existing canals as of few years back. So to devise adjustment measures in 1970, the federal government, at the request of the provinces, appointed a committee, first a committee led by Justice Akbar and another commission led by Justice Halim, to examine the problem of interprovincial apportionment. But a consensus could not be reached amongst the provinces between 71 and 91. Therefore, there was no formal allocation system that specified the volume of water each province received from the Indus waters. The federal government distributed the water on an ad hoc basis for each crop season. The situation was such that the existing arrangements did not allow the extension of the irrigation network to new areas, and construction of new projects. A formal arrangement was therefore deemed necessary. On 6th of March 1991, a water apportionment accord was signed by the chief ministers of the four provinces. The accord fixed the quantum of water shared amongst them, established a system for future allocation, and enabled them to determine the location of storage projects based on their share. This is the water allocation, water sharing on regular channels. And this table comes from the accord. I'll not go and discuss this. This was not all. The accord also included some other provisions that are of importance. Under the accord, for example, the NWFP, the Northwest Frontier Province, and Balochistan projects under execution were allotted their authorized quota of water as existing use. The balance of river supplies was distributed amongst the four provinces. The accord also specified that the industrial and urban water supplies for Karachi, for which there were sanctioned allocations, would be given priority. Storage, where feasible, would be planned for future agricultural development. The accord recognized the need for minimum water conveyance to sea to check seawater intrusion. Further studies would be undertaken to establish the minimum level. Under the accord, the province also could undertake new projects on small schemes not exceeding 5,000 acres above elevation of 1,200 feet. Developing irrigation use in the Kuram, Gomal, and Kohat basins were also allowed, so long as they did not adversely affect the existing use. Balochistan was allowed to develop the water resources of the Indus right bank tributaries flowing through its areas. The accord also clarified that the requirements of the left bank outfall drain would be met out of the flood supplies. The system-wise allocation would be worked out separately on a 10-day basis and would be integrated part of the accord. The record of the actual average system use for the period 77 to 82 would form the guidelines for developing a future regulation pattern. The 10-day use would be adjusted pro rata to correspond to the indicated seasonal allocations of the different canal systems and would form the basis for sharing shortage and surpluses. Please note these two last points, the system-wise regarding system-wise allocation. We will be discussing this again a bit later. But before we do that, let's finish what the other provisions of the accord are. The accord also specified that the operations of the existing reservoirs would give priority to irrigation, but the provinces could modify system-wise and period-wise uses within their allocation. And lastly, surpluses, if any, could be used by another province, but without establishing any permanent right. The Council of Common Interest, let's call it CCI, which actually is a constitutional body appointed by the president on the advice of the prime minister. This CCI ratified the accord on March 21, 1991. I must point out that prior to 1970, water was distributed pursuant to the 1945 Sindh Punjab Agreement. And this agreement was pre-partition that provided a solution on the two provinces that gave priority to Sindh's rights to receive water from the Indus. From 70 onward, distribution started to be based on ad hoc arrangements decided by the federal government. Every year, and it would do that every year on a season to season basis. This ad hoc distribution was provisional in nature and without prejudice to the claims of the provinces. This 1991 accord changed. This system was changed by the accord. The accord provided for the establishment of an Indus River System Authority. We will call it IRSA, with mandate to regulate the distribution of water among provinces to ensure that each province gets its allotted share and to facilitate agreements on equitable inter-province allocations. IRSA, with representation from all four provinces, was operationalized in 1993. It was originally based in Lahore, headquartered in Lahore, but later it moved to Islamabad. IRSA's establishment has been useful, except that it has not been able to resolve or prevent any dispute. For instance, between Sindh and Punjab, Sindh demands its share as per the formula in the accord, and Punjab on the basis of historical use. That's where the tension, Punjab-Sindh tension, comes into play. And this tension came into being, in my view, due to three main reasons. First, increase in demand caused by change of weather patterns and urbanization. Room for interpretation left by the accord. And last but not least, involvement of multiple institutions in decision making, too many institutions. Let us reconsider para 14A of the accord. We discussed earlier, but now we'll focus on it a bit more. Paragraph 14A talks about system-wise allocation. It states the system-wise allocation will be worked out separately on a 10 daily basis and will be attached with this agreement as part and parcel of it. So recognizing that there will be shortage to meet the requirement of the existing canal under conditions of uncertain availability, another relevant provision was included, and that was paragraph 14B. 14B states the record of actual average system uses for the period 1977 to 82 would form the guideline for developing future regulation patterns. These 10 daily use would be allotted, these 10-day use would be adjusted pro rata to correspond to the indicated seasonal allocations of different canal systems and would form the basis for sharing shortage and surpluses on all Pakistan basis. 6 months after the accord, the conclusion of the accord, on 16th September 1991, the CCI held a meeting to decide on a 10-day average season-wise allocation for the provinces. In the meeting, Punjab emphasized that it would not be appropriate to take any one paragraph of the accord in isolation, and the 10 daily system-wise allocation should not be made without protecting the existing use and deciding on future storage. But Sindh had a different view. It said that providing data on 10 daily average allocation on a system-wise basis was already integral part of the accord. It was not appropriate to link any other issue with its provisions. Sindh emphasized that the 91 Accord be implemented strictly. After considering Punjab's and Sindh's viewpoints, the CCI authorized 10 daily seasonal system-wise adjusted allocation provided by the provinces to become part and parcel of the accord. Here, we must note that the CCI did not agree with Punjab's view that the existing sharing arrangements had to continue during deficit period in the absence of storage construction. It is also useful, in my view, to refer to another paragraph of the accord, paragraph 6. It states that the need for storage wherever feasible on the Indus and other river was admitted for planned future agricultural development. This, in my view, suggests that future storage is not connected with sharing of water in the existing canal system. But Punjab's general position has to be understood. It was that the 1991 Accord reduced its share by 2.7% and increased Sindh's share by 1.2%. Under the 91 Accord, Punjab secured an allocation of 55.94 million acre feet, and Sindh secured an allocation of 48.76 million acre feet. In the case of Sindh, its pre-accord sanctioned allocation was 48.74 million acre feet, with the sanctioned allocation of 2.24 for LBOD project. Sindh's pre-accord sanctioned allocation was 50.98 million acre feet. However, under the 91 Accord, it received only 48.76 million acre feet. Then I think we need to talk about the Inter-Province Ministerial Committee. On May 2nd, 1994, Punjab, there was a meeting organized by this committee, and Punjab presented a working paper at that meeting. To deal with the shortage of water between Punjab and Sindh, it proposed that the sharing be based on 1977-82 average use. The proposal was opposed by Sindh. For Sindh, it violated the 91 Accord and was against an earlier decision of the CCI. What is interesting is that, surprisingly, the minutes of the IPMC, the Ministerial Committee meeting, included a statement recording Sindh's agreement to the proposal. And seeing that, Sindh's member, in a letter to the Pakistani Secretary of the Ministry of Power and Water, protested that it would be a travesty of truth and distortion to state that there was a consensus on the historical use for sharing shortage. He insisted that the sharing of shortage needs to be pursuant to Para 2 of the Accord, not for historical use. In this connection, the Special Secretary of the Pakistani Minister of Water and Power, in a letter to the Chairman of IRSA, reminded that IRSA was vested with full authority for resolving interprovincial conflicts issues. The role of IPMC, the Ministerial Committee, was only advisory, primarily assisting IRSA to reach a consensus through a spirit of goodwill and cooperation. All decisions were ultimately the responsibility of IRSA to ensure fair and equitable distribution of water among provinces. And as such, water continued to be distributed pursuant to Para 2 of the 91 Accord until Kharif of 1999. But in Rabi 1999, IRSA arbitrarily decided to follow the decision of 1994. Sindh opposed. The chairman of IRSA then referred Sindh's opposition to the Pakistani Secretary of Water and Power. That matter was further referred to the Ministry of Law, for interpretation of para 14 of the 1991 Accord. The law division commented that per plain interpretation of para 14, the 10 daily use having become part and parcel of the accord had to be adjusted pro rata for sharing shortage. Any interpretation to share shortage on historic use basis would be a violation of the accord. The law division, added that para 13 under para 13, IRSA was responsible for implementing the accord, and disputes, if any, on the subject should be referred to CCI, forming any other body for decision making or interpretation would distort the accord and violate the constitution. The law division recommended, however, that since the aggrieved party had not referred the matter to CCI, the existing arrangements as decided by IRSA may continue until a decision is made by CCI. On this matter, the Chief Executive Secretariat also issued a directive stating that all instructions given on the issue by the Chief Executive regarding IRSA needed to be implemented promptly along with the 1991 Accord. As a follow-up, the chairman of IRSA notified all concerned that the decision of the 1994 IPMC meeting stood annulled. But interestingly, IRSA notified the provinces about the directive only after 8 months. Therefore, until then, water was being distributed according to the annulled 1994 IPMC meeting, not the minutes of the meeting, not under the 91 Accord. In 2001, the opinion of the law division and the directive of the chief executive were placed before the law minister, who agreed with their conclusions. Consequently, the law division issued a revised note annulling the award of the 1994 ministerial meeting and recommending the implementation of the 1991 Accord. The government of Punjab, as a last-minute attempt, made another request, asking the law division to review the earlier opinion by examining para 14 of the accord. But on that, the law division was categorical. It responded that the 1973 rules of business provide a hierarchy by the authorities for resolving conflict of opinion. And since the issue had been examined by the federal law minister as well as the chief executive of Pakistan, the law division could neither reopen nor review the earlier communication. The chief executive secretariat also wrote that IRSA had no legal, technical, and moral justification to distribute water under the annulled 1994 ministerial decision. It urged that this gross violation be stopped and Sindh be compensated for the loss of last 3 years' supply of water to the extent of 2 million acre-feet from its allocated share in the accord. Such have been the back and forth. And despite all the above, according to the information, the shortage of water is still being shared under the 94 ministerial meetings formula and surplus under the 1991 Accord. So that is the situation, and I will stop here. In tomorrow's session, I will talk about this India segment, the impact on India. For today, I will stop here. Thank you very much.